welcome, honourable members, members of the media, and a very warm welcome to our presenters this morning. By way of introduction, I've introduced my committee to you. As on my left is Honourable Selai Andi Baitonga of the government, Honourable Mikaela Leweri of the opposition. On my right is Honourable Pio Tuhunduundua from the opposition. We also have Honourable Dr. Salik, who may be joining us a little later this morning, who is presently in another committee. We're ably assisted by Jacob and his assistant, Darylyn, at the rear, or behind you, rather. And then on my far right is Tatila from the Hansards. With the words of introduction, I welcome the Fiji Human Rights Fiji Women's Rights Movement and the Office of the Solicitor General. With that word of introduction, I now give you the floor to Ms. Artika Singh of the Fiji Women's Rights Movement. Thank you.
Thank you, sir. I'm Artika Singh from Fiji Women's Rights Movement. I'm here with my colleagues Chris Prasad and Benis Lata, and we'll be making our submission on the ratification of the Violence and Harassment Convention of 2019. Okay. The Fiji Women's Rights Movement, established in 1986, is a multi-ethnic and multicultural non-governmental organization committed to removing all forms of discrimination against women through institutional reform and attitudinal change through targeted research and advocacy. FWRM is the only domestic non-governmental organization dedicated to undertaking research in areas affecting women, including sexual harassment at the workplace. FWRM notes that at the time of preparing this submission, there have been nil ratifications by any country to the Violence and Harassment Convention of 2019. This gives Fiji a unique opportunity to be the first country in the world to ratify this convention and thereby cement its position as being a champion of women's rights to be free from violence and harassment in the workplace. FWRM will also address some concerns raised. Additionally, as per the concluding observations of the Committee on the Elimination of Discrimination Against Women, in the 5th periodic report of Fiji, it calls the state parties' attention to the fact that sexual harassment does not only constitute an attack on the dignity of the women, but additionally has a discriminatory impact, as it will often affect the victim in terms of wages, promotion, and/or dismissal, as well as create a hostile work environment which obstructs the victim's fulfillment of her professional potential. FWRM takes this opportunity to submit herein our recommendations to the Committee on the ratification of the Violence and Harassment Convention. In terms of the prevalence of sexual harassment in the workplace in Fiji, FWRM's work in the area of employment reform as it relates to advancing women's rights began in the late 1990s under its Women's Employment and Economic Rights Project. The goal was to redress the social and economic disadvantaged women in the wake of labor reforms occurring in Fiji at the time. We recognize that sexual harassment is more than a problem of safety and health and unacceptable working conditions, but is also a form of violence, primarily against women. In 2002, FWRM commissioned a Tibet research to conduct a groundbreaking research on the incidence and nature of sexual harassment of women in the workplace. This was the first ever research on the prevalence of sexual harassment in Fiji. The results of that study were widely utilized and assisted FWRM to lobby and advocate against sexual harassment in the workplace and to provide input into a decision to adopt a broader definition of sexual harassment for Employment Relations Act being developed at that time. In June 2016, FWRM again commissioned Tibet Research to update the findings by conducting a follow-up study. The core research objective was to replicate and update the key elements of the 2002 study, while incorporating some changes to make the project relevant to the 2016 workplace. A quantitative study with 1,000 women currently in paid employment was conducted in the urban centers of Suva, Nadi, Lautoka, and Lambasa. This study asks the question, has the prevalence of sexual harassment in the workplace changed with the increasing number of women in the workforce and/or with the increasing number of women in the decision-making roles? Whilst the incidence of sexual harassment in the workplace in 2016 as compared to 2002 has decreased. The findings of the research point out interesting relations to Fiji's economic development in past decade. The food, beverage, and hospitality sector has the highest incidence of sexual harassment, which is 35%, followed by public service, which is 25%, health at 24%, retail at 23%, and education at 8%, the sector being the lowest. In the study, Nandi, which has 35%, was identified as the hotspot for incidences, followed by Suva with 19%, Lambasa 18%, and Lautoka 11%. In 2002, Lautoka was reported to be the hotspot for sexual harassment. Two hypotheses can be formed on the improvement in the situation on Lautoka. One, being the tourism infrastructure or restructure has contributed to this, and two, the expiry of the multi-fiber agreement in 2005, which saw the demise of many garment establishments in the city. Younger women, 25% of under 30-year-olds, and those women from Itoke, those women who are Itoke, stand at 29%, are more likely to be harassed as are casual 43% and part-time 30% employees. Incidences are higher for women with these job requirements: serving members of the public, working on weekends, working at night, shift work, changing in and out of uniforms at the workplace, working on own in isolation, attending office parties. The most common types of sexual harassment that women face is verbal, 12%, gestural, 10%, physical, 9%. Most types of harassments are happening at the usual place of work and has occurred in the last 12 months. Most types have been experienced in the current organization rather than previous organizations, indicating that majority women remain in workplaces where they experienced sexual harassment. The study confirms that majority of the offenders are male, with the proportion being females. Most of these offenders were between the ages of 20 to 39 years. Therefore, young males are most likely to offend. For the 20% of women who have experienced sexual harassment in the workplace, half have experienced more than one type of sexual harassment. Those working in the food, beverage, and hospitality sector are most likely to report multiplicity, that means 10% or more than 4 types of offenses. In the 2016 survey, the idea of sexual harassment instigated through communal or family ties, that is Tauvu, Tavale, etc., was explored. Almost 1 in 8 women claim to have experienced sexual harassment in the workplace or during the course of doing a job that was the result of traditional, cultural, or kinship relationship. The decrease in the incidences of sexual harassment in the workplace is encouraging. However, more work needs to be done for the workplaces to adopt and implement sexual harassment policies that are consistent with the national standards as stated in the Employment Relations Act, with strong patterns indicating high prevalence in the food, beverage, and hospitality sector. Advocacy and knowledge base on sexual harassment needs to be strengthened across this country. Most young people being victims and offenders of sexual harassment in the workplace indicates a long-term issue, since these people will remain in the workforce for a very long time. Issues with the current legislative framework. The National Sexual Harassment Policy, which is a guiding policy document, unfortunately has not been able to contribute to the eradication of sexual harassment in the workplace faced by women, as our research shows. As per our research, despite 20% of all working women were interviewed stating they experienced sexual harassment at their workplaces, only 18% reported it. These incidents occurred whilst national legislation and policy framework was in place to date. FWRM is deeply concerned at these figures. This is due to multiple reasons, such as the current national sexual harassment policy has not been reviewed since 2008, the non-inclusion of social media as a means of perpetuating sexual harassment, and outdated references to the Penal Code, which is now repealed by the Crimes Act. The current laws and policies, which are the Employment Relations Act, the National Gender Policy, and the National Sexual Harassment Policy, lack uniformity and relevancy in addressing the issue of sexual harassment in the workplace. For example, we note the submissions made by the disciplined forces to the Standing Committee last week in support of ratification. However, it is worth highlighting that the ERA does not apply to the members of Fiji Correction Service, Fiji Police Forces, and Republic of Fiji Military Forces, as per Section 3, Subsection 2. They may have their own internal processes for dealing with sexual harassment and violence cases, but we are not privy to this information. Furthermore, the CEDAW committee had put forward the following recommendations related to sexual harassment, to examine the organizational culture in workplaces to address the factors that may facilitate sexual harassment and or assault, to widely disseminate information on reporting procedures, ensuring that the complaints are investigated and perpetrators are brought to justice, conducting regular labor inspections to verify the sexual harassment policy being in place, and amending the Employment Relations Act to ensure that it applies to all employers, including the Republic of Fiji Military Forces, the Fiji Police Force, and the Fiji Correction Service. In terms of our recommendation, FWRM strongly recommends that the state ratify the convention, as it would bring the timely review of all the relevant national laws and policy which need updating. We also recommend that all sectors be included under the one regulation for easier recording, monitoring, and evaluation purposes, as well as ensure greater and exemplary transparency and accountability. When we have uniform and transparent reporting processes and an assurance of fair and just outcome, this in turn results in more victims and survivors speaking up and coming out to report their cases, as they would have faith in the system. This would also ensure that Fiji is meeting all its international obligations under the Sustainable Development Goals with violence-free workplaces and decent work for all. Thank you.
Thank you, Mrs. Atika Singh, for your very informative submission on the subject matter. Honourable members, do you have any questions for Fiji Women's Rights Movement? I just have one, Ms. Singh.
Sure.
If you don't mind just sort of enlightening us on the multi-fiber agreement.
Yes.
And what does that entail? Thank you.
Yes, so we had made reference to multi-fiber agreement because, just a minute. The multi-fiber agreement was in relation to the garment factories that protected garment workers. Not sure. Are you sure about it? Do you want to respond? No. We'll have Ms. Denise Luther responding.
Thank you, Chair. I believe that reference in our submissions, the reason why we referred to the collapse of that agreement was because it directly reflected in our research. When we did the previous research, I believe in 2002, we saw that Lautoka had the highest numbers in terms of sexual harassment at the workplace, which was a direct result of more women who were working in the garment industry. And so when this agreement, when there were less women in Lautoka working in the garment industry, that is when, as a result of this agreement falling through and there were less women working in the garment industry in Lautoka, that's when we saw the numbers shifting away from Lautoka and going to hotspots like Nandi. That is the reference that we made. It was a result of that in our research that we saw the shift in numbers from the 2002 research and when we compared it to the 2016 research. But the prevalence was still high at the, in our research in 2016.
Thank you, Ms. Lata. Having said that, so who or which authority developed the agreement?
Chair, we do have to apologize. If we can get some time to respond to your question, we'll get that information across to your office.
Thank you, ma'am. That is appreciated. Thank you much. Honourable?
Just a quick one, Chair. Thank you, ladies, for a very informative presentation. And we recognize your support for the ratification of this particular treaty. I'm just curious at the content of some of the data that you have, but in particular, two things. One, this survey on sexual harassment, the victims, the report, and I'm referring to the fourth paragraph on page 2 of your report from the top, noting that that the majority of women, reporting sexual harassment, it's okay. Is that am I thinking correct here, or most likely to be harassed?
I'm most likely to be harassed.
Most likely. Okay. Is there a certain reason behind that?
Yes.
Okay.
Sir.
Okay. Can you
So-
just sort of tell us why?
So-
And maybe also, whilst you're thinking of that, later on you said, therefore, young males are most likely to offend. Would it be correct to assume that the majority of the offenders in that regard are Itoke males also? Would you have that data?
We would not have the data on the second part of your question.
Okay.
Sir.
What of the first part?
Yes, for the first part, we had said that the younger women who are the 25% of under 30-year-olds and women who are ethocrape, so 29%, are most likely to be harassed. And we have listed down places where they are most likely to be harassed, but if there is any particular reason as to why they are being harassed, we are not aware of that. When we did a prevalence study in relation to this, we had asked different people in all the diversities, and Itoke women said that they are most likely, and the research found that they are most likely to be sexually harassed.
Just a simple question. Is that an assumption, or is it?
Sorry?
Is it an assumption?
No, sir, this is not an assumption. This is what the research found.
Thank you. With no further questions, I'll now give the floor to the Solicitor General's office. Thank you.
Honourable Chair and honourable members, good morning. My name is Seema Chand, and I'm here with my colleague David Solvalu, and we're from the Solicitor General's office. This morning we'll be presenting on the three treaties, the Violence and Harassment Convention, the OHS Convention, and also the Nuclear Weapons Convention. Honourable Chair, I seek your indulgence whether you would like us to present on the first to the Violence and Harassment Convention first, and then go ahead with the nuclear treaty, or would you like us to submit on the nuclear treaty first?
However, the floor is yours. Thank you.
Thank you, Honourable Chair, Honourable Members. As Seema has already introduced me, but just again for the record, my name is David Solvalu, and I'm with the Office of the Solicitor General, and I will be presenting on the Treaty on the Prohibition of Nuclear Weapons. I also have with me Mr. Chochi Washington, who is with the Ministry of Defense. He has accompanied me to assist in the case of if the committee has any questions that relate to enforcement or ministry capacity or history of this document during the negotiations or any part before it was made. He would be in a better position to assist. So I shall begin. The Treaty for the Prohibition of Nuclear Weapons, it basically sets out a set of prohibitions against participating in any nuclear weapon activities. So these include undertakings by member states to not develop, test, produce, acquire, process, stockpile, use, or threaten to use nuclear weapons. It also prohibits deployment of nuclear weapons on national territory and the provision of assistance to any state in the conduct of prohibited activities. State parties are obliged to prevent and suppress any activity prohibited under the treaty, undertaken by persons or on territories under its jurisdiction or control. The treaty also obliges states parties to provide adequate assistance to individuals affected by the use or testing of nuclear weapons, as well as to take necessary and appropriate measures of environmental remediation in areas under its jurisdiction or control contaminated as a result of activities related to the testing or use of nuclear weapons. So that's basically the treaty in a nutshell. So Fiji signed this treaty at the signing ceremony on 20th September 2017. There are currently 81 signatories to the treaty and only 35 ratifications. In order for this treaty to come into force, there needs to be 50 ratifications. So currently, this treaty is not in force. It will enter into force 90 days after the 50th instrument of ratification. So as already stated, it tries to create a framework for clear prohibition of nuclear weapons activities, and it needs the support of the international community. It needs as many ratifications as it can get in order to get it over the line. And by ratifying this convention, this treaty, Fiji will be adding its support to an international effort to stop the use of nuclear weapons. The treaty also complements the existing nuclear disarmament instruments, which are the two most important or worth mentioning are the Treaty on the Non-Proliferation of Nuclear Weapons and the Comprehensive Nuclear Test Ban Treaty. Fiji has ratified both. However, it's important to note that the Comprehensive Nuclear Test Ban Treaty is also currently not in force, as it also does not have the necessary ratifications. So I will now go through each article of the convention and just speaking briefly on them. So it contains 20 articles, and under Article 16, parties to the treaty are not able to make reservations. So ratification of this treaty would mean ratification of it in its entirety. Article 1 prohibits the activities I already mentioned in the introduction. Article 2 requires each party to, within 30 days from the date the treaty enters into force, declare whether it has previously owned, possessed, or controlled nuclear weapons, which in this case we have not. Article 3 requires parties that don't possess nuclear weapons to maintain their existing International Atomic Energy Agency safeguards, and if they haven't already done so, to conclude IAEA safeguards and bring into force a comprehensive CSA. Fiji currently has a comprehensive CSA. It's been in place since 1973. Comprehensive safeguard agreement is actually where it's established under the International Atomic Energy Agency statute and also under the Non-Proliferation of Nuclear Weapons Treaty. It is an agreement that where a state undertakes to accept IAEA safeguards in accordance with the terms of the safeguards on source or special material in relation to nuclear activities within the territory of the state. The CSI requires states basically to declare and submit regular reports on their nuclear material and their nuclear facilities, and to accept inspections and other measures by the IAEA to verify these declarations and reports. So in 1973, Fiji entered into a CSA agreement. Fiji also has a small quantities protocol in force, which essentially reduces the burden of implementation of the provisions of our CSA. This is the SQP is a process that was initiated because quite a few countries that were parties to the Non-Proliferation Treaty, they actually had little or no nuclear weapons or nuclear material. So the reporting requirements under the then CSA was quite comprehensive. So in order to cater for the countries with little or no nuclear materials, a small quantities protocol was brought into place, which Fiji has, and this protocol it's been in place for a while now, and it basically softens the CSA, but because we have little to no nuclear material, it doesn't detrimentally affect the international framework. So, moving on, Article 4 sets out general procedures for negotiations with an individual nuclear armed state becoming party to the treaty, including time limits and responsibilities. If the state has eliminated its nuclear weapons before becoming a party to the treaty, A competent international authority will verify that elimination, and the state must also conclude a safeguards agreement with the IAEA to provide credible assurance that it has not diverted nuclear material and has no undeclared nuclear material or activities. If a state has not yet destroyed its nuclear arsenal, it must negotiate with a competent international authority a time-bound plan for the verified and irreversible elimination of its nuclear weapons program, which will submit at the next meeting of signing states or to the next review conference, whichever comes first. At this point, it's probably important to note the difference between this treaty, the Prohibition of Nuclear Weapons Treaty, and the Non-Proliferation Treaty, is that non-proliferation, the NPT was more focused on disarmament, and it sort of secured the monopoly that existing nuclear weapons armed countries had and prohibited the proliferation of those weapons further. But this treaty is a sort of a response to Article 6 of the NPT, which envisioned a time when all nuclear weapons would be prohibited in their entirety. This treaty seeks to bring that into effect, seeks to create a world where all nuclear weapons are prohibited in their entirety. So again, the NPT was about phasing out, but the the Prohibition Treaty is about completely eliminating. Article 5 of the treaty requires states parties to undertake appropriate legal, administrative, and other measures, including the imposition of penal sanctions to prevent and suppress any activity prohibited to a state party under the treaty. So, as was provided in the implementation phase of the part of the written analysis, moving forward, it might be prudent to review our national legislation in order to see ways in which we can give better effect to this treaty. So currently under the Public Order Act, we do have a set of prohibitions. These prohibitions deal with use, threat of use, transfer, receipt, and transport of nuclear weapons materials. However, given the comprehensive and quite detailed list of prohibitions in the treaty, it might be prudent moving forward to see ways to better enforce these prohibitions. Article 6 requires states parties to adequately provide age and gender-sensitive assistance without discrimination, including medical care, rehabilitation, and psychological support to individuals under the state party's jurisdiction who are affected by the use or testing of nuclear weapons, as well as provide for their social and economic inclusion. So Article 6 is to do with reparation, is to do with ensuring that people who have been negatively affected within a state party's jurisdiction, they receive some form of assistance. This is a state obligation, so by Fiji ratifying this treaty and becoming a party to it, Fiji will then have a new binding obligation to ensure that Fijians who are detrimentally or adversely affected by nuclear activities have support, financial support, and also psychological support and various forms of assistance. So this state obligation is further supported by the international community under Article 7, because Article 7, it contains a three-part, if the honourable members would look at Article 7, it actually can be broken down into three parts. The first is in paragraph 2, which allows for states to seek assistance from other states parties. So a country could utilize this mechanism to seek assistance from other states parties in order to fulfill its obligations under the treaty. So if our obligations under Article 6 is to ensure that our victims of nuclear weapons or nuclear activities are taken care of, then Article 7, paragraph 2 allows us to seek assistance from other states in order to fulfill this obligation. Paragraph 4 refers to voluntary assistance. So that's the other part of the framework. It allows for states to voluntarily provide assistance, regardless of whether those states were nuclear armed states or not. And paragraph 6, which is the third part of Article 7 of relevance, it creates a binding obligation on states parties to the treaty which have who have been nuclear armed or have partaken in nuclear weapons activities to ensure that those people who have been harmed by those activities, receive some form of assistance. It also, very interestingly, it also ensures that these states seek environmental remediation, which means that the harm that they have done to the environment, they also seek to address that harm. The Article 7 is actually an achievement was an achievement. Mr. Washington could probably tell you more, but Article 7 was a huge achievement for the negotiators, because it is part of a treaty that, for the first time in relation to nuclear weapons, creates an assistance and state responsibility notion, which is that states that have nuclear weapons activities now have a legal obligation to ensure that they provide assistance and environmental remediation. So this is something that Fiji also pushed during the negotiations behind this treaty, because the concept of states taking responsibility for their actions was something that we found it was very important, particularly in relation to this situation. So that's there in Article 7. Article 8 provides for meetings of state parties to consider and take decisions in relation to the application and implementation of the treaty. The first meeting will occur 1 year after the treaty enters into force. Articles 10 to 12 provide processes for amendments to the treaty, settlement of disputes, or I should say a voluntary settlement of disputes through a negotiated mechanism between two or more states parties, and the promotion of the goal of universal adherence of all states to the treaty. So basically the goal of universal adherence, promoting that goal, means states parties to the treaty try to get other states to also come on board this international framework. Articles 13 to 15 set out the processes for the treaty to be open for signature, which it was on the 20th of September 2017, and it sets out when the treaty enters into force. Article 16, as I've already said, states that the treaty shall not be subject to reservations. Article 17 provides that the treaty shall be of unlimited duration, though each state party shall have the sovereign right to withdraw from the treaty if such state party is of the view that the subject matter of the treaty jeopardizes the supreme interests of the country. Article 18 provides that the treaty shall not prejudice the obligations of states under other agreements where such obligations are consistent with the treaty. Article 19 states that the depository is the UN Secretary General, and Article 20 requires the text of the treaty to be in the 6 United Nations languages, which is is a staple for UN conventions. So for implementation, I've already, in the process of going through the articles, I've already talked about the implementation bits. But basically, we will have to ensure that we would have a binding obligation to ensure that none of the prohibited activities Fiji takes part in or are taken part in our jurisdiction. And that basically is the treaty. It supports our international commitments that we've made so far. We've also been, apart from the two treaties I mentioned, the NPT, the Non-Proliferation Treaty, and the Nuclear Test Ban Treaty, we also have the South Pacific Nuclear Free Zone Treaty, which is really a concerted regional effort to ensure that our end of the Pacific is safe from nuclear weapons, and Fiji has been a vocal supporter of this treaty. And that's basically the treaty will promote cooperation and strengthen international relations with other state parties who have acceded to or ratified the convention, and further Fiji's goal of ensuring a nuclear weapon-free world. That, and our recommendation, of course, is that Fiji ratify the treaty without reservations.
Thank you, Mr. Solvalu, for your analysis of the treaty before us. Honourable members, do you have any question on that treaty? Or thank you, Honourable.
Thank you, Chair. My question is on Article 7. Was there any room for retrospective application for victims of, nuclear tests, of the past when they negotiated this? Or even in the future, will there be any room for that?
It's not a time-bound provision. It is just an obligation, existing obligation. So it will be, it will apply, yes.
You think so you can apply this retrospectively then for all the tests in Muraro and everywhere else?
Yes.
Excellent. Okay, thank you.
No further questions, honourable members. I'll now pass the floor on to Ms. Seema Chand. Thank you.
Thank you, Honourable Chair. Honourable members, I'll be presenting on two conventions this morning. The first being the ILO Convention 190 on violence and harassment, and the second being the P1155 Protocol of 2002 to the Occupational Health and Safety Convention 1981. Honourable members, I understand that you would have already in front of you the summary of the convention, which was provided beforehand, the requirements for implementation and the impact of the convention. So in the interest of time, I won't take you through each and every article. But what I will do this morning is essentially talk about the legislative framework that we have in place already, and do a pure legal analysis of this convention, vis-a-vis our national laws. So the first, piece of legislation that I'd like to draw your attention to this morning is the Fijian Constitution. And that is Section 11 in particular of the Fijian Constitution, which provides as follows, and it's pertaining to the freedom from cruel and degrading treatment. And the article essentially, or the section 11 essentially states that every person has a right to freedom from torture of any kind, whether physical, mental, emotional, and from cruel, inhumane, degrading, or disproportionately severe treatment or punishment. Subsection 2 provides that every person has the right to security of the person, which includes the right to be free from any form of violence, from any source, at home, school, work, or any other place. Subsection 3 further provides that every person has the right to freedom from scientific or medical treatment or procedures without an order of the court or without his or her informed consent, or if he or she is incapable of giving informed consent, without the informed consent of a lawful guardian. Honourable members, at this point I'd like to highlight that with respect to Fiji and in the scope of Section 11, this extends to violence, which is intersectional and also includes intersectional forms of sexual harassment and violence. And it also, confirms that torture is not just about physical torture. It can be mental and it can be emotional. So we've got a very salient and salutary provision in Section 11 already in our Constitution. I'll now talk briefly about our Employment Relations Act. Sexual harassment is actually defined under Section 4 of the ERA, and it states that sexual harassment means when a worker is sexually harassed in his or her workplace or places where workers are gathered for work-related purposes, including social activity, when an employer or its representatives or a co-worker, A, makes a request of a worker for sexual intercourse, sexual contact, or any other form of sexual activity which contains an implied or overt, 1, promise of preferential treatment in that worker's employment, 2, threat of detrimental treatment in that worker's employment, or 3, threat about the present or future employment status of that worker. sexual harassment is the clause further in part B also says that by the use of a word, whether written or spoken, of a sexual nature or materials of a sexual nature, C, by physical behavior or gestures of a sexual nature, or D, creates an intimidating, hostile, or humiliating work environment by conduct, word, or both on the basis of gender, that subjects the worker to behavior which is unwelcome or offensive to that worker, whether or not it is conveyed to the employer, its representative, or the perpetrator, and which is either repeated or such a nature that it has a detrimental effect on the worker's employment, job performance, or job satisfaction. In this context, detrimental effect includes the creation of an environment which affects the worker's physical, emotional, or mental health and well-being. Therefore, the definition of sexual harassment under Fiji's laws is one that is progressive because it encompasses both the conduct of a sexual nature defined under A, B, and C, and conduct of sexist nature under D. Paragraph D covers conduct which is bullying, hostile, or degrading conduct which targets persons from vulnerable groups, including those persons from the LGBTI groups and with respect to persons with disabilities. The definition acknowledges that the harassment at the workplace is a form of discrimination against groups identified which are vulnerable, and that the word sexual is not just a reference to the type of the harassing act. It is also a form of discrimination against women on the basis of gender. Honourable members, we also have a national policy on sexual harassment at the workplace. This is a 2008 policy, and it's a fair. I have the policy with me. It is annexed to the Employment Relations Act, and so there are various sections to the policy with respect to the operating principles, definition of sexual harassment, the employer's responsibilities, a worker's responsibilities, a complaints mechanism and statutory rights, and so forth. So I'll just talk a little bit about the national sexual harassment policy at the workplace that we currently have. So sexual harassment under the policy is actually described as a form of discrimination and a gross violation of a person's human rights and dignity, and can occur at two levels. One, in relationships of unequal power or authority, as in staff/student or supervisor/subordinate relationships, and between peers or co-workers, that is worker to worker or colleagues. The sexual harassment policies outlines, various responsibilities, by employers, and these are that every employer must have an internal written policy and grievance procedure on sexual harassment at the workplace. It is pivotal that both staff and managers collaborate in developing such a policy so that both parties are committed to the process and its outcome. This approach ensures that a policy is reflective of employer and worker safety needs. So it's more about a collaborative approach. You can't do this in isolation. You must, as an employer, you also must consult your employees. Furthermore, it is important that such a policy is devised by the employer and workers that reflects the basic principle that both the complainant and the harasser have rights that will be adequately protected by such a policy. The policy statement should articulate that fact, and that sexual harassment can be verbal, gestural, visual, or physical in nature. More importantly, an employer must have clear, prompt, and informal and formal procedures for counteracting sexual harassment in the workplace. An employer may wish to consider utilizing the existing health and safety committees within an organization or workplace if there is one. An officer of the health and safety committee of a workplace could function as a sexual harassment grievance officer. This officer should be experienced and have skills in mediation, negotiation, and conflict resolution in order to resolve complaints of this nature. They must be gender sensitized and fully conversant with workers' rights and responsibilities to enable them to arrive at a proper and informed decision regarding the manner in which the complainant may get his or her grievance addressed. Measures that may be adopted in reinforcing the prevention and eradication of sexual harassment in the workplace are: 1, the use of pamphlets and posters to reinforce the message that sexual harassment in the workplace will not be tolerated; orientation programs that include the dissemination of information on sexual harassment, ongoing training for staff members on their responsibility for maintaining a workplace free of harassment, information about employer liability and the monetary costs related of workplace harassment, and materials such as case studies dealing with incidents of harassment. The policy also sets out the remedies available to the complainant and requires a process of monitoring in the following terms. One, every workplace must have a sexual harassment monitoring and evaluation system in place to maintain and enhance a work culture of mutual respect and understanding. In this regard, all complaints or grievances should be documented thoroughly and be handled with strict confidentiality by all concerned, so that action taken to address complaints and grievances is effectively addressed. These records could then be used as a tool in evaluating the success of internal strategies as well as the national policy, and ensuring that a harassment claim is handled properly and promptly. Should there be questions later as to whether a harassment claim was properly handled, the records would provide the required information. Records also enable recurring patterns of behavior or ongoing problems in a particular work area to be detected and corrective action to be taken. Honourable members, so with respect to Fijian laws, if you look at our constitution, the Employment Relations Act as well, under the Employment Relations Act, we've got, a section on sexual harassment, how it's defined, the responsibilities of employers under those, under those various sections. And then we've got this, the national policy on sexual harassment at the workplace, which is an old policy. It was established in 2008. But having said that, there really is no impediment, no legal impediment as to why Fiji shouldn't ratify this convention. If anything, it supports the legal framework that we have in place at the moment. And our submission this morning really is that, we recommend that Fiji ratify the convention. Thank you.
Honourable members, you have any question on that first protocol? Thank you.
No, I'm sorry, Chair. It's Ms. Chan's to pose the question to you, Chair. Thank you. Very interesting, Ms. Chan, in terms of your presentation. You mentioned something about also legal requirements that are already in place, the Fiji Constitution, ERA, and with this convention coming into force, when it's being ratified, do you think, in your view, will this come under one umbrella, or are they going to be like that in terms of this convention, and then we have the laws, the legal requirements that are already in existence in Fiji? Just your views on that. Thank you, Honourable Chair.
Thank you, Honourable Member, for the question. So the convention is the international standard, and is international customary law. So you've got the convention, and then once you ratify the convention, you have an obligation as a state party to then look at your domestic legislations, your national laws, and to make sure that your national laws are in compliance of the convention. So if you're falling short anywhere, you may wish to review, you may wish to amend. If it's a policy document, you may wish to look at, revise the policy document. So that's essentially your benchmark, to meet the obligations. I also want to just reiterate to the committee this morning. This convention is a fairly new convention, and it was adopted on the 21st of June last year. And so because it's a new convention, currently to date, there are no countries, no states that have ratified this convention. So if Fiji was to ratify, it could realistically be the first in the world to actually ratify this convention.
Honourable members? Thank you, Honourable.
Yeah. Chair, thank you for that. Ms. Chanda, thank you for your presentation. Very interesting, and as you said, this deserves all our support. No? Particularly because most of the vulnerable fall into this category: women, children. And you mentioned the LGBTs and those parts of our community that really needs our attention. And I'm just curious because you said that our current existing laws actually, pretty much fulfill much of the requirements of the convention now that it's just coming lately, and we're going to support it. Curiously, and you know, I have no problems with that. But my observations yesterday for the speakers that came is that we seem to have inadequate laws. But it appears that that the commission of these acts continue to grow. I'm not sure whether it's society or it's the law that's the problem. I don't think it's the law, but it's how we follow the law. And I say this because, I mean, even the sexual violence against women, you know, in the recent past is, you know, is being done by people who live in this house, where this convention is now going to be put for ratification. Now, I would just like to, particularly where, you know, most of our laws and policies for government are driven, you know, through the legal framework by your office, that some capacity is put into how, you know, how these laws can be, I don't know, I mean, I do not have the answer to it, but, you know, not sure if it's even your job, but I'm stating to you because I mean the inception of the legal framework comes from you, and then we have, you know, the Fiji women's rights movements here who keep saying that these figures keep going up, but maybe there needs to be some check and balance now, some creation of innovative ideas about really how to make this legal framework work, because it would appear socially it's not working. Maybe it's just the way that the laws have to be written, or some smarter guys in drafting needs to look at that. I mean, this is just an observation I'm giving here, because like yesterday when others came to talk, I said, well, you know, Parliament keeps hearing every day about these rises of you know, sexual harassment and violence. It's, you know, our society is getting tired of it. So I don't know if the law is the answer. I really hope, because, you know, the law is being drafted and created by your office. You offer, you know, the legal assistance to the House in that matter, that maybe that we need to look at it this other side, the practical side of, you know, of making the policy work, making the law work, you know, without becoming too draconian about this matter. And I know some countries do it, but maybe we should start looking at it, because right now, I think we're all concerned that it looks like our country is becoming unsafe for our own children and our own mothers and our daughters and those who are vulnerable in society. So I really hope, and I you know, I share that with you now, because there's not very many frameworks where we do. Maybe you can look at, you know, sort of a more, I'm not sure, practical way. Because otherwise then the law just becomes fast, because, I mean, as it is done right here in this house. Thank you.
Thank you, Honourable Member, for your comments. And I do share your comments that you can have a robust legislative framework in place, but usually it's attitudinal barriers that are the hardest to overcome. So whether it involves more training and development, and you know, in terms of that respect, you know, I thank you for your comments in that regard.
Thank you, Honourable Member. No further question. We'll ask Ms. Chan to continue with the second protocol. Thank you.
Thank you, honourable members. So my second presentation this morning is with respect to P155, the Protocol of 2002 to the Occupational Health and Safety Convention 1981. And I understand, as with the previous convention, you already have a summary of the protocol in terms of the summary of each article, the requirements for implementation, and the impact of the convention. So in the interest of time, I won't touch on that. But again, I'll do a legal analysis and I'll just look at the legal framework that we have currently in place. So just by way of background, Fiji ratified the International Labour Organizational Occupational Safety and Health Convention 1981 on the 28th of May 2008. Article 4 of the convention requires every state party to formulate, implement, and review a coherent national policy on OHS and the working environment. In order to ensure the progressive work of each state party's commitment under Article 4 of the Convention, the relevant functions of the competent authorities, as set out in Article 11 of the Convention, include: 1. The establishment of an application of procedures for the notification of occupational accidents and diseases by employers and others directly concerned, and the production of annual statistics on occupational accidents and diseases. And 2, the publication annually of information on measures taken in pursuance of the policy on occupational accidents, occupational diseases, and other injuries to health which arise in the course of or in connection with work. Now, in order to give effect to the national policy commitment under Article 4 of the Convention, the relevant functions of the state party's competent authority provided under Article 11 of the Convention, and the need to strengthen recording and notification procedures for occupational accidents and diseases, the ILO General Conference adopted the Protocol of 2002 to the Convention to address the proposals. As such, the protocol was then adopted on the 20th of June 2002 and came into force on the 9th of February 2005. Honourable members, under Section 20 of the Fijian Constitution, every person has the right to fair employment practices, including humane treatment and proper working conditions. The Health and Safety at Work Act 1996 and the Health and Safety at Work Administration Regulations 1997 provide the minimum requirements pertaining to health and safety at work. In this regard, they provide for the systems of notification and recordings of occupational accidents, occupational diseases, dangerous occurrences, and suspected cases of occupational diseases by the employers and the competent authorities in Fiji. Section 26(1) of the Act, which is the Health and Safety at Work Act, provides the following with regards to notifications of accidents and other matters where A, an accident occurs at the workplace, whether or not it causes the death of or bodily injury to any person, or B, any other matter occurs at or in relation to a workplace which affects the health and safety of any person, being an accident, or any other matter which is required by the regulations to be notified under this section, and C, the employer at the workplace or such other person as is prescribed shall give notice of the accident or other matter to the Chief Health and Safety Inspector. Furthermore, Regulation 6 of the Health and Safety Work Regulations requires every employer to, as soon as possible, but no later than 48 hours after the occurrence of the accident or disease occurs at the workplace or any other matter that occurs at or in relation to a workplace which affects the health and safety of any person, to give to the Chief Health and Safety Inspector written notice of the occurrence. So there's already legislative provisions that mandate that as soon as something happens with respect to an accident at work or a disease outbreak at work, you must notify, an employer must notify the Chief Health Inspector, not less than 48 hours. The regulations, the Health and Safety at Work regulations, further stipulate that every notice shall specify the name, place, and residence and age of every person who is killed or suffered an injury or illness as a result of an accident, incident, disease, or other matter. The notice is also required to provide the nature and circumstances of the accident, incident, disease, or other matter, and the details relating to the accuracy of the place where the accident, incident, disease, or other matter occurred. The regulations also provide for the offence of failing to notify accidents, deaths, and injuries and occupational diseases at the workplace. And failure to do so, employers are liable to a fine of not more than $10,000. And in the case of a corporation, and $5,000 in any other case. Honourable members, I understand that the Ministry of Employment would have made a presentation to you on this convention, so we support their submissions, and we also state, or we also submit rather, that the Ministry of Employment, Productivity and Industrial Relations, through its National Occupational Health and Safety at Workers Compensation Service, has maintained the records of workplace accidents and injuries from 1996, and that is since the Act was essentially enacted. The statistics are used by the ministry to determine and analyze high-risk industries or workplace activities, the main causes of incidents, the nature of injuries, and the death rates by age groups. It also records and analyzes a total number of injuries and death reported compared to those that are assessed to be work-related for compensation purposes. The ministry, we understand, has also over the years put in place laws and policies that prevent accidents, such as the Health and Safety at Work Control of Hazardous Substances Regulations 2006, and the Health and Safety at Work Diving Regulations 2006. The ministry is also currently formulating regulations and code of practice in the areas of construction, plants and machineries, amusement rides, sawmills, maritime, and other, and they're also engaging in other occupational health promotions. Therefore, in conclusion, honourable members, we submit that under this protocol, our biggest obligation is to make sure that we have incidents being reported, that it's there tangibly, that when something happens at work, the employer is mandated under national law to report it to the relevant authorities. And so we're doing this already. The ministry is doing this since 1996. Data is there, and because we are in compliance with the articles of the protocol, there is no impediment to ratifying the protocol. Thank you, honourable members.
Thank you, Ms. Chan, for your observation of the protocol and the Occupational Safety and Health Convention. Honourable members, you have any questions for the team? Dr. Govind?
Thank you. This protocol calls for timely notification of accidents and injuries and occupational related diseases. My question is, for accidents and injuries, it's easy to report, but for occupational diseases, which have very long latent period, where the employee may already have left the employment and then develop the disease. So how does the office and also the employment ministry sees in terms of capacity? But it's not the employer who will be able to detect these diseases. It has to be a competent authority, a medical personnel, whom the employer has to access, or the client has to access. So what do you think it's that kind of capacity here to report, especially the occupational diseases in the past, especially diseases related to asbestos and other chemicals which are subjected? Is there capacity there to detect those occupational diseases?
Thank you, honourable member, for that question. Systems for recording and notification is actually outlined in Article 2 and Article 3 of the from Article 2 to Article 5 of the actual convention. It doesn't impose a timeline per se under these articles, but what we have is under our laws, we've got that no less than 48-hour period for employers to notify the appropriate authority with respect to any occupational accidents or incidents or diseases at work. With respect to capacity and whether or not information is given in a timely manner, it would be pertinent for that question to be directed to the Ministry of Employment, as the ministry actually is the implementation agency for that provision. So they would be able to give you all of the statistics that they've collected and how soon or what is the competency like with respect to any sort of diseases, a disease outbreak at work, etc., under our Health and Safety Act and regulations.
Honourable members, any further question? No? Sorry, Mr. Salvala, you wish to make a comment? Thank you.
Hi, yes, honorable member. I just wanted to also point out that under the Accident Compensation Act of 2017, but I think since 2018, the Accident Compensation Framework has been extended. Sorry, I think that was 2019. The Accident Compensation Framework was extended to include employment-related accidents. So under the Accident Compensation Employment Regulations, there is compensation, which is a no-fault basis compensation, which is paid out from the Accident Compensation Commission, Fiji. So in relation to prescribed diseases, the process for prescribed diseases is that if a person has suffered a disease that's connected to their workplace, they have 24 months. So in order to, so if the disease develops later, they have 24 months. So they would get a medical certificate confirming that they have a disease and that the disease occurred in the 24 months prior to the medical certificate. If they can get that medical certificate, and they will also have to provide a list of all of their employers to the Accident Compensation Commission Fiji, but the Accident Compensation Commission will be the one compensating them for their prescribed disease.
Mr. Salvala, you mentioned within the 24-month time frame on leaving or resigning or retiring from the entity.
So they could be still employed, they could be unemployed and have been employed in the last 24 months, but so long as they have they get a medical certificate that shows that they have this disease and that this disease was contracted in the past 24 months, and that link in the past 24 months is the link to whoever employed them in the past 24 months. That is in relation to acquiring information, but the compensation itself comes from the Accident Compensation Commission.
Yeah, for some of these, and what Honourable Dr. Govind is referring to, diseases or sicknesses that occur well after 24 months, a couple of years. If you're if the employee is being exposed to asbestos, particularly, that's a disease that goes into the lung, and asbestos is so fine that even the hair in the nostrils will not have it collected. It'll find its way straight down to your lungs, and it builds up in your lungs, and that's what kills a person without him even knowing that he is got that. But on autopsy, it'll be found out that he has that. But there's other things like chemicals within the paint manufacturers, the LPG industry, and abroad, ammonia industry, that sort of thing. So I guess I appreciate your answer there, Mr. Solvalu. However, it's probably something that we need to look at the Employment Regulations Act again. Yeah, thank you very much for that. No further questions, honourable members. I take this opportunity to thank both the Fiji Women's Movement and also the Office of the Solicitor General. Thank you all once again. Naka.